video is I'm going to try to read through the homework that I need to do with you. So today we'll be reading Schneck v. United States. Schneck v. United States. So I'll just read out loud to you, and you might hear my pencil writing on this, and we'll see how this video goes. So let's get into it. Okay. I have to find where it starts. Gitlow v. New York. Is that the right case? Is that the right case? I don't know. Hold on. It has to be. So we'll start reading. Gitlow v. New York. Heir to the Supreme Court, New York, Mr. Justice Sanford delivered the opinion of the court. Benjamin Gitlow was indicted and convicted for the statutory crime, criminal anarchy. New York penal law. Contingent here is the statute. I'm gonna get closer. Uh-oh. I just dropped my pencil, but I had another one right here, so I don't have to go digging for it. Amazing. Contention here is that the statute, by its terms and as applied, in this case, is repugnant to the Due Process Clause of the 14th Amendment. The indictment was in 2 counts. The first charge that the defendant had advocated, advised, and taught the duty necessary and propriety of overthrowing and overturning organized government by force, violence, and unlawful as well as citizens. The left-wing section was organized nationally at a conference in New York City in June 1919. The conference elected a national council of which the defendant was a member, and left to it the adoption of a manifesto, in quotes. This was published in the Revolutionary Age, the official organ of the left wing. The defendant was on the board of managers of the paper and was its business manager. He arranged for the printing of the paper and took the printer the manuscript of the first, which contained the left-wing manifesto and also a communist program and a program of the left wing that had been adopted by the conference. 16,000 copies were printed, which were delivered to the premises in New York City. 16,000 copies. That's a lot. The printing credit is 5 cents, and they had 16,000. 5 times 16 is what? 80. So 80 with 3 zeros after it. Wow. 80,000. Oh, but then you'd have to move the decimal. You'd have to move the decimal over 2 points. So 80,000 has 80, then 3 zeros minus 2 zeros. So that's really just 8 zeros. It would be $800 to print 16,000 copies at Emerson. As long as it's one page. Wow. 6,000 copies were printed, which were delivered at the premises in New York City, used as the office of the Revolutionary Age at the headquarters of the left wing, and occupied by the defendant and other officials. It was admitted that the defendant signed a card subscribing to the manifesto and program of the left wing, which all applicants were required to sign before being admitted to membership, that he went to different parts of the state to speak to branches of the Socialist Party about the principles of the left wing and advocated their adoption, and that he was responsible for the manifesto as it appeared, that he knew of the publication in a general way, that he knew of its publications afterwards, and is responsible for its circulation. He was responsible for the manifesto. Gotta put all of that in a big... Oh, I broke my pencil. Big box. What happened? Okay. There was no evidence of any effect resulting from the publication and circulation of the manifesto. No witnesses were offered in behalf of the defendant. Compelled with a review of the rise of socialism, the manifesto condemned the dominant moderate socialism for its recognition of the necessity of the democratic parliamentary state, and advocated in plain and unequivocal languages the necessity of accomplishing the communist revolution by a militant and revolutionary socialism. manifesto, that a mere statement or analysis of social and economic facts and historical incidents in the nature of an essay accompanied by prophecy as to the future course of events, but with no teaching, advice, or advocacy of action, would not constitute the advocacy, advice, or teaching of a doctrine for the overthrow of the government within the meaning of the statute. Starting out, where to go. The jury. Keep dropping stuff. Oh no, I messed up. Okay, back. Teaching of a doctrine. Overthrow the government within the meaning of the statute. I believe this takes place during the Red Scare. So, that must be it. Like, they're afraid they're trying to overthrow the government with communism, which is why this man was not allowed to hand out his pamphlets. That's what they're called. So they're trying to figure out if this person was actively trying to overthrow the government. Interesting. The defendant's counsel submitted 2 requests to charge, which embodied in substance the statement that to constitute criminal anarchy within the meaning of the statute, it was necessary that the language used or published should advocate, teach, or advise the duty, necessity, or prophecy of doing some defined, definite, or immediate acts or act of force, violence, or unlawfulness directed towards the overthrowing of organized government. These were denied further than had been charged. The sole content here is essentially that there was no evidence of any concrete result flowing from the publication of the manifesto or of circumstances showing the likelihood of such result. The statute, as contrived and applied by the trial court, penalizes the mere utterance as such of doctrine having no quality of incitement, without regard either to the circumstances of its utterance or the likelihood of unlawful consequences, and that as the exercise of the right of free expression with relation to government is only punishable in circumstances involving likelihood of substance evil and statute contraveness. CONTRAVENES. statute takes no account of circumstances. It unduly restrains the liberty and is therefore unconstitutional. The statute does not penalize the utterance or publication of abstract doctrine or academic discussion having no quality of incitement to any concrete action. It is not aimed against mere historical or philosophical essays. It does not restrain the advocacy of changes in the form of government by constitutional and lawful means. What it prohibits is language advocating, advising, or teaching the overthrow of organized government by unlawful means. These words imply urging to action. The manifesto plainly is neither the statement of abstract doctrine nor, as suggested by counsel, mere prediction that industrial distributions and revolutionary mass strikes will result spontaneously in an inevitable process of evolution in the economic system. It advocates and urges in fervent language mass action, which should progressively ferment industrial disturbances, and though political mass strikes and revolutionary mass action overthrow and destroy organized parliamentary government, it concludes with a call to action in these words. The proletarian revolution and the communist reconstruction of society, the struggle for these is now indispensable. The Communist International calls for the proletariat of the world to be the final struggle. Final struggle, final struggle, final struggle. If I just put a box around there. Gotta go down. This is not the expression of philosophical abstraction, the mere prediction of future events, in its language of direct incitement. Not expression of philosophical abstraction. The means advocated for bringing about the destruction of organized parliamentary government, namely mass industrial revolts, usurping the functions of municipal government, political mass strikes directed against the parliamentary state, and revolutionary mass action for its final destruction, necessarily imply the use of force and violence, and in their essential nature are inherently unlawful in a constitutional government of law and order, that the jury were warranted in finding that the manifesto advocated not merely the abstract doctrine of overthrowing organized government by force, violence, and unlawful means, but action to the end is clear. Not merely the abstract. personal rights and liberties protected by the Due Process Clause of the 14th Amendment. This is a dance between the First Amendment and the 14th Amendment. It is a fundamental principle long established that the freedom of speech and the press, which is secured by the Constitution, does not confer an absolute right to speak or publish without responsibility. Does not absolute right to speak or publish without. Whenever one may choose that a state in the exercise of its police power may be punished, those who abuse this freedom by utterances imbecile to the public welfare, tending to corrupt public morals, incite in crime, or disturb the public peace, is not open to question, and for yet more imperative reasons, a state may punish utterances engaged by the foundations of organized government and threatening its overthrow by unlawful means. In short, this freedom does not deprive a state of the primary and essential rights of preservation. By enacting the present state, and the state has determined, though its legislative body, the utterance advocating the overthrow of organized government by force, violence, and unlawful means, are so inimical, to the general welfare, and involved such danger of subsistence evil that they may be penalized with the exercise of its police power. That determination must be given great weight, every presumption to be indulged in favor of the validity of statute. Mulger v. Kansas. That uncertainties inciting the overthrow of organized government by unlawful means present a sufficient danger of substantive evil to bring their punishment within the range of legislative discretion is clear. Such utterances by their very nature involve danger to the public peace and to the security of How many pages are there? Oh my god. Long. The state they threatened. Gotta take a head scratching break. The state they threatened breaches of peace and ultimate revolution, and the immediate danger is nonetheless real and substantial because the reasonably by required to measure the danger from each such utterance in the nice balance of a jeweler's scale. A single revolutionary spark may kindle a fire that, smoldering from a time, may burst into a sweeping and destructive conflagration. It cannot be said that the state is acting arbitrarily or unreasonably when in the exercise of its judgment as the measure necessary to protect the public peace and safety. It seeks to extinguish the spark without waiting until the enkindled the flame or blaze onto the conflagration. It cannot reasonably be required to defer the adoption of measures for its own peace and safety until the revolutionary utterance lead to actual disturbances of the public peace or imminent the immediate danger of its own destruction, but it may, in the exercise of its judgment, suppress the threatened danger in its incipient We cannot hold that present statute is an arbitrary or unreasonable exercise of police power. The statute unwarrantably infringes the freedom of speech or press, and we must sustain its constitutionality. This being so, it may be applied to every utterance, not too trivial to be beneath the notice of the law, which is of such a character and used with such intent and purpose as to bring it within the prohibition of the statute. In other words, when this legislative body have determined generally in the controversial exercise of its disintegration that utterance of a certain kind involves such danger of substantive evil that they may be punished, the question whether any specific utterance coming within the prohibited class is likely in and of itself to bring about the substantive evil is not open to consideration. It is sufficient that the statute itself be constitutional and that the use of the language comes within its prohibition. It is clear that the question in such cases is entirely different from that involved in those cases where the statute merely prohibits certain acts involving the danger of substantive evil without any reference to language itself. It is sought to apply its provisions to language used by the defendant of the purpose of bringing about the prohibited results. There, if it be continued that the statute cannot be applied to the language used by defendants because the protection by the freedom of speech or press, it must necessarily be found as an original question whether any previously determined by the legislative body, whether specific language used involves such likelihood of bringing about substantive evil as to deprive involves such likelihoods of bringing about substantive evil as to deprive it in the constitutional protection. In such cases, it has been held that the general provisions of the statute may constitutionally applied to the specific utterances of the defendant if its natural tendency and probable effect was to bring about the substantive evil which the legislative body might prevent, and the general statement in Schneck that the question in every case is whether the words are used in such circumstances and are of such nature as to create a clear present danger that they will bring about the substantive evils upon which great reliance is placed in the defendant's argument was manifestly intended, as shown by the context, to apply only in cases of the class, and no application to those likely to present where the legislative body itself previously determined the danger of substantive evil arising from the utterance of specified characters. It was not necessarily within the meaning of the statute that the defendant should have advocated some definitive or immediate actions or acts of force and violence or unlawfulness. It was sufficient if such acts were advocated in general terms, and it was not essential that their immediate execution should be advocated, nor Was it necessary for the language should have been reasonably and ordinarily calculated to incite certain persons to act or force violence or unlawfulness? The advocacy needed not be addressed to specific persons. Thus, the publication and circulation of a newspaper article may be an encouragement or endeavor to persuade to murder, although not addressed to any person in particular. We need not enter upon a consideration of English common law, said the seditious libel or Federal Sedition Act of 1798, to which reference is made in the defendant's brief. They are so unlike the present statute that we think the decisions under them cast no helpful light upon questions here. Affirmed. Oh, so that's the court case. And now there is a dissent. Okay. Mr. Justice Holmes dissenting. Mr. Justice Brandeis and I are of the opinion that this judgment should be reserved. The general principle of free speech, it seems to me, must be taken to be included in the 14th Amendment in view of the scope that it has been given to the word liberty, as there used, although perhaps it may be accepted with somewhat larger latitude or interpretation than is allowed. The Congress, by sweeping language that governs or ought to govern the laws of the United States. If I am right, then I think the criterion sanctioned, that is the singular version of criteria, I believe, criterion sanctioned by the full court in Schnick applies. It is true that in my opinion this criterion was departed from in Abrams, but the convictions that I expressed in that cause are too deep for it to be possible for me as yet to believe that it and Schaffer v. United States, that's the second case, Schaffer v. United States have settled the law. If what I think the correct test is applied, it's manifest and there was no present danger of an attempt to overthrow the government by force on the part of the admittedly small minority who shared the defendant's views. It is said that this manifesto was more than a theory, that it was an incitement. Every idea is an incitement. It offers itself for belief, and if believed, it is acted on unless some other belief outweighs it or some failure of energy stifles the movement at its birth. The only difference between the expression of an opinion and the incitement in the narrower sense is the speaker's enthusiasm for the result. Eloquence may set to fire, but whatever may be thought of the redundant discourse before it has no chance of starting a present conflagration. If in the long run the beliefs expressed in the proletarian dictatorship are dissented to be accepted by the dominant forces of the community, the only meaning of free speech is that they should be given their chance to have their way. If the publication of this document had been laid as an attempt to introduce an uprising against government at once and not at some indefinite time in the future, it would have persisted a different question. The object would have been one of which the law might deal, the subject of doubt whether there was any danger that the publication could produce any results, or in other words, whether it was not futile and too remote from possible consequences. But the indictment alleges the publication and nothing more. Again, I break my pencil. Not. And that is the end of that court case. I'm sorry. This was not the most interesting video. I'm not quite sure if I will end up posting it, but if you liked it, tell me if you did. If you didn't like it, sorry. Some people like read out louds, and I figured 2 birds with 1 stone, right? But no matter how you felt, if you stuck with me this long, thank you very much for watching.